Invasion of privacy.
What's that?
It's the means by which this guy lost his family, friends, and everything else he holds dear to him. So privacy law is the area of law concerned with the protection and preservation of the privacy rights of individuals. Increasingly, governments and other public as well as private organizations collect vast amounts of personal information about individuals for a variety of purposes. The law of privacy regulates this type of information which may be collected and how this information may be used and stored. We got it from Wikipedia, it must be true. Perhaps the most significant suit in establishing our modern Georgia privacy law is Pavesic versus New England Life Insurance Company. So, you know this guy? Good, no one does. But a guy just like him, oblivious and unsuspecting, had photos taken of him too, Paulo Pavesic. And he got pretty pissed when he heard that there were pictures of him floating around in public. What had happened was that a photographer took some pictures of him. The photographer needed some cash, so he sold the pictures to this insurance company, who was looking for modeling talent for an ad. The problem was, Paulo knew nothing about this deal. He was extremely upset when he saw a picture of him spread across the Atlanta Journal-Constitution, advocating a company he had never heard of. Justice Andrew Cobb lists several reasons for the unanimous decision in Pavesic versus New England Life Insurance Company. 1. The absence of a precedent for a right does not conclude the question of the existence of that right. In other words, just because this right has never been disputed before doesn't mean that it doesn't exist. 2. The right to privacy is derived from natural law, recognized by municipal law, and embraces far more freedom than physical restraint. So this law is acknowledged by city officials and should protect the private lives of citizens, even if they aren't physically violated. 3. The right of privacy gives an individual the right to enjoy life as long as he doesn't invade the rights of his neighbor or violate public law or policy. 4. The right of privacy is unquestionably limited by the right to speak and print when exercised within the limits of constitutional guarantees. So the First Amendment says, Congress shall make no law, blah blah blah. This includes the privacy law. The government prohibits privacy law from affecting freedom of speech, religion, press, assembly, and government petition. 5. In addition to the amendments in the U.S. Constitution, the Georgia Constitution also forbids the abuse of freedom of speech and of the press. It's the same law, different source. 6. One's right of privacy can be waived, except regarding matters in which law or policy demand it be sustained. The problem with this law, however, is that it's difficult to determine when the law carries precedence over a citizen's own personal interests. This difficulty was illustrated in a case involving the Macon television studio WMAZ, which incidentally was established here at Mercer, and a man with AIDS. WMAZ was sued after agreeing to conceal his identity on screen, and then failed to do so. Several other state criminal statutes deal with invasions of privacy, encompassing prohibitions against eavesdropping, wiretapping, peeping toms, and proper surveillance, including the use of hidden cameras, and the intentional interception of a cellular telephone signal or dissemination of its contents without the consent of at least one party to the conversation. Though many other battles have been fought and won in the ongoing dispute of privacy law in Georgia, Pavesic versus New England Life Insurance Company was the most groundbreaking of all the cases thus far, and continues to prove a useful resource to victims of invasion of privacy in Georgia today. That's the end!